Thank you for joining us for today's session, where we'll be looking at commercial property law and introducing the basic concepts. My name is Stephen Smith, and I'm delighted to be joined, as always, by Ian Quayle and my colleague Robert Kelly. Good morning to you both.
Good morning.
Good morning.
Before I hand over to Ian for the main part of the presentation, I'd just like to go over a few items so you know how to participate in today's event. I'm sure a few of you are new to these webinars that we're hosting. You're listening in through your computer system by default. If you would prefer to join over the telephone, you can just select the telephone option in the audio pane and the dial-in information will be displayed. This is a toll-free number, so it will only be local charges or charges to you or your company that would apply. You will have the opportunity to submit any questions, text questions to Ian by typing your questions in the questions pane of your control panel. You can send questions in at any time during the presentation, and we will collect these and address them during a Q&A at the end of today's presentation. You can also raise your hand. There's a little raised hand button on your control panel during the presentation. If you're having any difficulties with the sound or other technical issues, we will be able to speak to you through the chat box feature and hopefully be able to resolve any of these issues. Finally, we have also included some notes for today's session. These will be in the handouts section of your control panel in about 5 or 10 minutes time. If you're having any issues accessing the notes, please do get in touch through the chat or Q&A function or email me, and you can email me by replying to the GoToWebinar emails you'll be receiving, and we will get these sent over to you. Anyway, I'll now pass over to Ian for the main part of today's presentation. Thanks, Ian.
Thanks, Stephen. Hello, everyone. Thanks for joining us today. Before we start, a massive thank you to Stewart Title, who are sponsoring this series. I work closely with Stewart Title and have done for a number of years. And as a company that provides title indemnity insurance, very, very impressive people to deal with, nice people to work with, good products. And again, from a local authority perspective, you may be of the view, well, we don't need title indemnity cover. In connection with some commercial transactions, it might be that you've got title that perhaps is defective. And rather than looking at sort of remedying the defect, it might be that you and indeed anyone acting on behalf of a buyer of a site from you would need to talk to someone about defective title insurance. And just as Stewart Title are very supportive of the legal profession with regard to providing events such as this free of charge, I would suggest that if ever you need title indemnity insurance, Stephen and Robert and their team are available to talk about the product, about the problem, about the issues and how they can help you. So a massive thank you to them. Yeah, as Stephen was saying, the purpose of this series of webinars is to sort of explore some issues relating to commercial property transactions. I have been a commercial property lawyer. I started off, that was my task, and spent many a happy year dealing with commercial property transactions. I've done a lot of work, consultancy work with local authorities. And one of the things when I started doing training 18, 19 years ago now, very quickly I realized that local authority lawyers, although dealing with sort of what I would class as mainstream commercial property transactions, also have lots of other things to deal with. And that's one of the things that we'll be touching on in addition to sort of looking at sort of commercial property transactions generally, looking at some issues that local authority lawyers have in particular. And the main issue that I frequently see is the fact that you're getting instructions from an estates team, and there can be issues with regard to the transmission of information from estates to you. In addition to that, that you could have it be involved in transactions where the issue is simply economics, and the idea is that we're looking to generate best value, but there can be other transactions where there are sensitivities. So you might be contemplating granting a lease to a sort of parish council or to a non-profit making organisation with which the local authority, county council, etc., has a sort of an accommodation, has an association with, and therefore it's not your standard commercial transaction. So I'll hopefully share with you some of my ideas relating to that, because I have encountered that quite frequently over the years. The purpose is to share with you my knowledge. As far as questions are concerned, as Steve says, you can fire away with questions at any stage in the chat facility. I'll also provide you with an email address if you have any questions or queries. And if you have any requirements for title indemnity policies or any information is sought with regard to that, then both Stephen and Robert's email addresses and contact details will be available to you. The first thing I want to do today is to share with you some very useful websites. And the first site that I commend to everyone is the Property Litigation Association website. It is free to access and contains a wealth of material that will be valuable to you as a commercial property lawyer. Just about every solicitor, every barrister or counsel, QC, that writes papers or opinions that end up in the Estates Gazette also find their way on the PLA website, and it's free to access. So if anyone today fired across to me a question concerning enforceability of an easement, enforceability of a restrictive covenant, had an issue with regard to a property joint venture, or anything else that I wasn't able to sort of assist with immediately, I'd probably go to the PLA website and use their search engine to see if there are any recent papers, opinions, or documents on that particular topic. Those of you that get involved in lease renewal, business lease renewal, there's also a protocol on that site that's very useful. So if you as a local authority were intending to object to a renewal of a lease, then you can have a look on the site and see what sort of evidence is required to substantiate an objection. Free and very useful. Second site, again, probably a site that you won't be familiar with, Property Protocols, devised by a number of QCs and some of the big city firms in London, creating a raft of protocols for different types of situation. One of the protocols that I recommend to residential and commercial property lawyers is the Boundary Dispute Protocol, which highlights how we deal with boundary sensitivity issues, which is of relevance to residential or commercial transactions, existing sites or development sites, etc. The third site I think is particularly important, and a site that if nothing else I'd ask you to have a look at. The City of London Law Society has a land law subcommittee site, and that site contains three things that I think will be of value to you. One, a series of precedents, including a commercial report on title, including a certificate of title, including a rent deposit deed, including standard clauses for commercial leases. In addition to that, there are a series of protocols, including electronic signature of documents and a whole raft of other resources that are free to access. So you've got that sort of library of information and data that I think is particularly useful. But in addition to that, you also have the committee itself, which flags up areas of reform, problem areas, and comes up with solutions and suggestions as to how those problems can be dealt with. So it acts as a radar for me with regard to what government thinking is, what the Law Commission is doing, and problems that commercial property lawyers are encountering. The final site that I mentioned is Property Law UK. This is a subscription site which I have a vested interest in, but which produces a monthly publication highlighting problems and issues for commercial property lawyers, property litigators, and residential conveyancers. We have 20 editors that will contribute on a monthly basis to, hey, as a conveyancer, you need to be aware of this, or you need to be aware of that. It is the only subscription service on this slide that I'm showing you. The first three I would recommend. Property Law UK, if you're interested, contact me and we can arrange for you to have a look at it in a little more detail. But the first three I would say are crucial. They'll contain free precedents, information and data that's going to be exceedingly useful for you. So if we're sort of starting off with commercial property transactions, I think it's a good idea to introduce the type of transaction that we could be dealing with. And the first is a sort of straightforward asset sale or purchase, relying on the standard commercial conditions of sale, third edition, relying on commercial inquiries before contract, and relying on standard conveyancing processes that you will have encountered in residential conveyancing. The idea of the seller producing title, the seller being obliged to disclose latent encumbrances, the buyer performing due diligence. As far as the asset sale and purchase is concerned, there are a number of radical differences between a commercial transaction and a residential transaction. Firstly, residential, we've got the conveyancing protocol, which acts as a framework, which acts as a sort of guidebook for the parties. The ethos of that protocol is that we are working as a team in connection with the conveyancing process. So we're not allowed to depart from the protocol unless absolutely necessary. We should be communicating effectively. We should be transparent with regard to our client's position. And the whole idea is that this is a teamwork ethos, sitting behind residential transactions. Commercial transactions are slightly different. The law sitting behind the process is exactly the same, but the emphasis is different. In a commercial transaction, you and I can split and apportion risk. So that could manifest itself in limitation or exclusion clauses within the contract. It could, for example, include an agreement that you will only be able to rely on replies to my commercial inquiries where I'm acting for a seller in a particular circumstances, or there might be a cap or a ceiling as to the amount that your client can claim in the event of misrepresentation. There could be all manner of different things in a commercial transaction that we wouldn't see in a residential transaction. Why? Put quite simply, the law's attitude is that if we're dealing with a commercial transaction, then the parties should have parity or equality of bargaining position. Theory, great. Reality, parity or equality of bargaining position will not exist, on the basis that, you know, if you're selling land and the market is tight and you've got a buyer, the buyer is going to impose terms on you, and you're going to be so delighted to be able to offload the property that you'll go along with whatever they want. Not generally speaking fair to think that there's parity where you've got a first-time buyer that's buying some commercial property, or someone fresh out of school or university that's taking a lease from a local authority, a business startup. Again, in those circumstances, we don't see that parity. But certainly we can, in a commercial transaction, be far more flexible with regard to how we apportion risk. I'm going to talk about commercial leases. I'm going to talk about dealing with business startups later in these presentations. Today, I just simply want to give an overview. So on a standard commercial sale or purchase, the purchase of the asset, the sale of the asset is the issue, and the deduction, the consideration of title, the due diligence that the buyer performs, again, something I'm sure that most practitioners, most conveyancers will be familiar with, even though they come at this from a residential perspective, perhaps. Acquisition of an SPV is slightly different, because here what we're doing is we're saying the building in the photograph is owned by a company, and what we're going to do is buy that company. Now, a lot of local authorities will farm that type of transaction out to external lawyers that will deal with the disposal or acquisition of an SPV. It might be that you as a property lawyer maintain a watching brief or actually participate in the transaction, but dealing with the property aspect. In those circumstances, you'd be looking at the share sale purchase agreement and looking at what is being sold. You would look at the warranties that are being given, and you would deal with the property warranties in conjunction with whoever was dealing with the commercial aspect of the transaction. With regard to acquisition of SPV, I would point you in the direction of the City of London Law Society's website, which contains a raft of information about SPV acquisition. I would always say, as a property lawyer in such transactions, you're driven by, governed by, and managed by your commercial team, or the external lawyers that are dealing with the commercial aspect. There is a sort of an unusual aspect of commercial transactions that most commercial property lawyers do not encounter. But if you're a local authority or a county council and you're selling to a blue chip company, okay, it's a big site, it's a high value site, it's a commercially sensitive site, you need to be aware of an unusual type of asset sale or purchase where a certificate of title is utilized. A certificate of title is produced by the seller's conveyancer, but is relied upon by the buyer. So let me explain how this might work. Let's assume that I am selling to your local authority a piece of land as part of an urban regeneration project. So you need this land as access, you need it in order to complete your site assembly for a big urban regeneration project, okay? My company does not want to put this property on the market. My client is commercially sensitive and doesn't want the world at large to know I'm offloading this to a local authority or county council. So what I could do is I could say, instead of you performing due diligence on behalf of the buyer, I will produce a certificate of title. To do that, my client will use a standard letter instructing me about what they know about the property that we're selling. That standard letter, the precedent, is available on the City of London Law Society's website. And I will then produce a certificate of title, taking into account what my client is saying and taking into account what I know about the property, having considered the title and other searches or other information that's on my file. So the buyer doesn't perform any due diligence at all. The buyer relies on what I say about the property. If what I say about the property is wrong or defective, you as a local authority will have a right to bring an action against the lawyer that drafted the certificate. The lawyer may be able to claim some form of indemnity from the client that provided the information, but you're relying on my certificate and you're dependent on my professional indemnity insurance in the event of a claim. Which leads to 2 points. Point number one, in that sort of situation, you need to check the level of indemnity cover that the solicitors that are producing the certificate of title are carrying. 2, you need to be very careful to make sure that you, your estates team, and your in-house officers understand and appreciate that you can't perform any form of due diligence at all. If you do, you potentially erode the value of the certificate that I've produced. So if your surveying team were to inspect the property, if your estates officers were to inspect the property and identify issues, then in those circumstances, there may be an argument that you didn't rely on my certificate, you relied on your own investigations, which would weaken your potential claim against me and my firm. So certificates of title, 2 things. 1, not commonplace, okay, quite rare. 2, normally high value transactions with quite sophisticated sellers or buyers. Used where, 1, there's commercially sensitive information relating to the sale that we don't want to get into the public domain. Or 2, where we want to move very swiftly. Because again, I've seen a certificate of title used where instructions have been obtained on the Monday and the transaction has been completed on the Wednesday. Because the buyer doesn't have to do any searches, the seller's lawyers already had all the information relating to the property to hand, simply received a letter of instruction from the seller client, produced a certificate, buyer then relies upon it, deal done. With regard to all of these things, I think with regard to working with local authorities, there are 3 problems. Problem number 1, the gaps, the failure to establish firm relationships with your estates department. With every local authority I've seen, and I've done a lot of in-house training, I've done consultancy work in connection with particular projects or with regard to the workings of the legal and estates team, I see a common thread and a common problem. A sort of a mismatch between what the estates team are doing and what the lawyers are doing. For example, if the estates team are negotiating the sale of a piece of land or a building, the estates department seem to market and do the deal and then go to the legal department and say, hey, this is the deal that we've done. I would much rather that the legal department has some input with regard to the decision to put the property on the market so that it can highlight, so that you can highlight the problems. So, hey, yeah, we've lost the title deeds to a bit of unregistered land that's part of this site. Or there's an issue with regard to the registered title as a boundary problem relating to this site, so that you can either 1, flag up the issue during the transaction, or 2, and better, sort the problem out. And it might be that where there's a defect in title, you could, as I mentioned a little earlier, speak to Stewart Title to see if it's possible to take out an indemnity policy and then say to the buyer, we have a problem with regard to this title. This is what it is, but we've spoken to Stewart Title, and you can take out an indemnity policy that covers off or deals with that risk. Again, be careful if you are even thinking about obtaining title indemnity insurance that you don't disclose the problem to third parties, or don't disclose to third parties the fact you're contemplating taking out a policy. It's safe to do it if you've got a buyer. It would not be safe if a property was being sold at auction, for example, to disclose in the auction pack the problem or the existence of a policy or the availability of a policy. So just a word of warning in that regard. So first problem, communication. I'm not saying that you get involved in the negotiation process with your estates team, far from it. I'm saying that you are aware that an asset is being sold. You can do an audit of the title before the sale starts, so you can flag up or deal with or attend to problems, so that you're familiar with the transaction from the start. To that end, you can have protocols, you can use heads of term, etc., that mean the estates department understand and appreciate the information that you need in order for the transaction to proceed smoothly. For example, the RICS has model heads of term in connection with commercial leases, which you can use as a model. The City of London Law Society's report on title, in essence, gives you a framework as to what the buyer is going to be thinking about relating to the title, that again can assist the estates team in seeing what we need to look at, where the pinch points might be with regard to the transaction that's being proposed. Problem number one, as I say, the estates team. Problem number two, and this applies on sales and purchases, objective. Why is your estates team selling this asset? Why are you buying in this asset? Why are you granting this lease? Are we granting a lease to the parish council on the basis that we are keen to ensure that the parish council thrives and the community thrives? Or are we looking at a lease on the basis that we want some repairs to be done to a building that we own? Or are we looking at this purely as an economic revenue generating transaction? Ascertaining the objective of the estates department, in my view, is very important indeed. The next thing that I mentioned with regard to the estates department and the relationship of the estates department is, again, making sure that we're reporting to the estates team what they want to hear. I haven't come across any local authority lawyers that are sort of sitting with their feet on their desk looking for work. Everyone I ever speak to is manically busy. And equally with regard to the estates team, similar principles can apply. So if you're dealing with an acquisition and you're sending to the estates team a 40-page report on title, is that going to be of benefit to the estates team, or is that just another headache? So do think about what you're reporting on, and can you make your reports on title more estates team friendly? Again, I refer you to the City of London Law Society's model form of report on title. You could utilize that as a starting point and then work from it and make sure that your estates team and you are ensuring that you're honing in on the information the estates team want to know about. I mentioned the resources that are available. One of the things, if you are looking for resources in connection with commercial leases, and as I mentioned, we're going to talk about commercial leases later, is this website that I show on the bottom here, modelcommerciallease.co.uk. Contains a raft of precedent leases that is quite useful for you, dealing with things like sort of startup tenants, dealing with sort of what I would class as traditional old-fashioned forms of commercial lease, etc. So again, just be aware of the resources. Just make sure that you're using these resources to make your life easier and also your estates team. So you can have a protocol with your estates team where in a report on title, it's agreed that certain things will be dealt with and certain things won't. It's important with a report on title that we provide a summary. So this is what our objective is as a local authority, and these are the key issues in this report that impinge or impact on that objective. Cover those off. Let's talk about corporate purchases for a moment or two. The share purchase agreement can be a complicated document. What we're looking for are the warranties that the seller is going to provide. And you may be asked to draft property warranties. Now, if you drop me a note by email, I can send you the list of sort of standard warranties that you'd expect to see in connection with a share purchase agreement. I've also got a checklist that we'd use with regard to the content of the agreement that might be of assistance to you. But in essence, if your local authority is selling an asset by way of share purchase agreement, so you've created an SPV that holds, I don't know, a sort of a restaurant or a sort of theatre or something of that nature, the local authority would give warranties as to the title that's being offered. You would then make disclosures against those warranties. In essence, what you're doing is eroding the warranties or the benefit of the warranties that you're providing. The idea of a share purchase agreement is that you are selling the company, not the land or the property itself. And therefore, when I mention, as far as having some corporate colleague working alongside you, it is absolutely essential that we perform due diligence, not just against the property itself, but against the company. So company accounts, contracts, etc., that the company has entered into. If you're acquiring the company, you as a local authority are going to be acquiring those contracts. If you're disposing of an SPV, similar principles apply. In connection with a corporate purchase, what you're doing with regard to drafting documents is you're creating a framework with regard to the transaction. You're not drafting or considering every eventuality, which is what you do with regard to a standard asset purchase or asset disposal. Again, I'm not going to dwell too much on this because it's not something that you're going to be encountering that frequently. I just want you to be aware of it, if that's okay. Talked about dealing with the estates department and clients. It's important to understand heads of term, protocols and systems, acquisition and disposal teams, something I haven't mentioned yet. Important that if you're dealing with an acquisition or a disposal, who within the local authority or county council is going to be part of the team. And where in particular you've got external advisors or external consultants being used, you need to know what their role is, and you need to know how and when you're going to communicate with them. And again, I think the important thing is in most transactions, it is your estates department that is going to act as the hub. So it's whoever the officer is within the estates department that's taking the lead that you're going to take instructions from. But at the start of the transaction, if I can provide you with heads of term, if I can say to you, look, these are the issues that I think are going to be relevant to the transaction, take those into account when you're negotiating with the other side, that's great. Protocols and systems come into play in that regard. As far as teamwork is concerned, we might have internal surveyors, external surveyors, we might have external sort of managers with regard to landlord and tenant relationships. If we're buying a building that's already let on commercial tenancies, we might have an acquisition of a property that includes residential and commercial elements, and therefore we might have two different estates teams dealing with the same transaction. We might also need to know what our planners think about what's being proposed by the estates department. We need to know who's involved, who communicates with whom, and we also need to understand and appreciate who our client is. And as I say, the default position normally will be the estates team. Ascertaining client objective, why we're buying, why we're selling, I think is so important. Now, let's talk about something slightly different for a moment. I touched on in my introduction the difference between residential and commercial transactions. As far as title is concerned, if we're selling, the same principle applies to a resi as opposed to a commercial transaction. If you're acting on the sale of property on behalf of a local authority, you need to perform an audit of the title. Where the land is unregistered, should we consider voluntary registration? I don't care how sophisticated the buyer client is, how experienced the buyer client solicitors are. Everyone seems to be far more comfortable buying registered land than unregistered land. The land registry's time for first registration is pretty scary at the moment. Last time I was speaking to the land registry, they were telling me it could take up to 12 months for an application for first registration of unregistered land. So if I'm buying a site in and I'm keen on funding it and using it as security for lending, I'm incorporating it into a bigger site, and I've got a pension fund that wants to fund it or wants to come in with me on a joint JV, the fact that I've got unregistered land that I'm buying, the fact that in essence it's going to take 12 months for that title to be registered is going to be a headache. If, on the other hand, the local authority can voluntarily register the land, life all of a sudden becomes a lot easier. And here's the rub. It's far easier and far swifter to apply for voluntary registration to get an unregistered title registered than an application for first registration. The land registry is throwing a lot of resource at voluntary registration and is keen to ensure unregistered land is registered. So if you have tracts of unregistered land within a local authority area or within a county council area, I'm fairly confident you'll have spoken with the land registry or they will have approached you about voluntary registration in any event. But where you have unregistered land that you're selling or that you are potentially going to sell in the near or middle future, it might pay to think about voluntary registration. The next thing I think is important to understand, where we're dealing with registered title, I think the land registration system is in essence a veneer. Where you've got a problem, you have to look at unregistered deeds and documents to try and decipher or resolve the problem. So let's create a little problem for ourselves. Let's assume that our local authority is selling a parcel of land at market value to a residential house builder. It's quite a tight, small site in an urban environment. The builder is paying market value plus for the site because it's nice and because it's neat, but there's a problem. And the problem is that the southwest boundary of this site is ill-defined. And we've got a neighbour that's aggressive, that's been in dispute with the council for many years, and who now thinks that their nuisance value, their dispute, all of a sudden becomes critical, all of a sudden becomes paramount, because in essence, it's going to block the deal with the national house builder. Okay? So what do you do in that situation? Well, just as you would with a residential transaction, there are a number of measures that are available. The first thing to state is that in those circumstances, a formal boundary agreement is unlikely to be achieved. A determined boundary application to the land registry is unlikely to be successful. But it might be that your estates team can do a deal with the neighbour that might be relinquishing a bit of land in their favour, but then getting an agreement as to where the boundary sits, making a determined boundary application to the land registry, meaning that our residential developer now no longer has a potential problem. I always say to conveyancers, residential or commercial, experienced or inexperienced, our job is to buy and sell property, not to buy and sell litigation. And if you as a local authority were selling that site to a developer, you might think, well, in selling it, that's us off the hook. It's now the developer's problem with regard to this dispute. What I would say to that is, in my experience, where there is a dispute of that nature, 2 or 3 problems can arise. Firstly, the fact that you're aware of it could lead to some vulnerability for a claim being made against you by the developer as a consequence of non or inadequate disclosure. Secondly, and more likely, the developer's got to sort out the problem, and to sort out the problem, they need your assistance. So you've closed the file, you're moving on to the next task in the mountain of tasks that you've got to do, and the developer's lawyer is at you about documents, about statements of truth, about what the estates department knew or didn't know about the problem. So again, title investigation, preparing sites for disposal, I think is just as critical as the actual task itself. Tidying up problems, being aware of defects and being aware of the need to disclose them, making sure that plans are professionally prepared. When I first started doing conveyancing, if I was selling off part of the site, I would get an ordnance survey plan on a Friday afternoon. If I was bored, I'd get the coloured pencils out and I'd sit with an A4 plan and I'd mark on what we were selling. And I'd attach that to the contract, and the other side would be quite happy with it. They would photocopy it, colour it, and attach it to the transfer. It would go off to the land registry and no one would hear anything more. These days, because of Land Registry Practice Guide 40, because of sensitivity that the Land Registry has with regard to indemnity claims, plans have to be Practice Guide 40 compliant. The idea of me sitting with my pencils and a ruler having half an hour of doing colouring in on a Friday afternoon is long gone. The plan is professionally prepared. The preparation of that plan will be an expensive exercise. If the plan is not adequate, the Land Registry will reject applications. So again, let's make sure our plan, it might be a lease plan, it might be a plan or a transfer of part, it might be a plan of the site, particularly if it's a development site that the builder wants, so that it can accurately identify what's being acquired, all of a sudden become critical issues. Remember, a land registry title plan cannot be relied upon to identify a legal boundary, so it's pretty much a waste of space and a waste of time. Boundaries cause problems. Adverse possession claims cause major problems for local authorities. So again, I would be, if I was selling land, be particularly jumpy and particularly worried if there was the slightest hint of a neighbour claiming adverse possession. If I'm looking at creation of policies and good estate management, would want my estates team to report to me anything that suggests there is the potential for an adverse possession claim being made. So my grass cutting teams reporting to estates that it appears some grass verge has been fenced off by a frontager, or a problem that the estates team are saying they've visited some premises and it appears that the owner of those premises has moved a fence or planted a new hedge that impinges on land that the council owns. These things cause problems. Remember, adverse possession of registered land, 10 years, unregistered land, 12 years. Again, remember that there are steps that can be taken, good estate management can be utilised to stop adverse possession claims from being brought. Again, it harks back to that relationship with your estates team, but again, touches on the fact that where we're dealing with a commercial transaction as a local authority, the fact we're not resident at the property, the fact that we're not seeing neighbours on a daily basis makes us more vulnerable to adverse possession claims being made. So again, if I'm auditing the title, I'm going to watch and I want my estates team to report to me the slightest hint of an adverse possession claim. Good tip, wherever you have a situation where an adverse possession claim has been made, the claim was unsuccessful, but the adverse possessor remains in situ. If the adverse possessor remains there for a period of 2 years further, they can bring a second claim that they're bound to succeed with. The other point that I think is important with regard to this issue in connection with commercial transactions is to watch where we're selling or acquiring an asset and the property that we're acquiring is tenanted. As a conveyancer, as a solicitor acting on the purchase of a building that's subject to occupational leases, a number of issues arise. Who's dealing with the management of those occupational leases? It might be the seller's estates team, or it might be a managing agent. Do I, as a conveyancer acting for the buyer, want to know about management issues, or is my client going to appoint a managing agent to deal with them? In which case, is data and information being transmitted from agent to agent, or is it being transmitted from seller's agent to me, and then me to the estates department of my local authority, or the external agent that's being instructed? I need to be careful with regard to that. If I'm buying a property that's subject to multiple occupational tenancies, commercial tenancies, I want to see the file, because although the seller is telling me there are tenants in there that are tenants that are not protected under the Landlord and Tenant Act 1954, I want to pressure test that view. Let's have a look at the file. Let's see that the lease has been contracted out. Let's check that there's been no holding over, etc., etc. Moving on, if possible, With regard to inquiries before contract in a commercial transaction, perfectly acceptable to limit the scope of our liability for misrepresentation, as I've mentioned. Also perfectly reasonable to utilise additional inquiries, whereas in a residential transaction that would be unfavourable, that would not be appropriate and protocol compliant. But in a commercial transaction, I would always say to my estates team, are there any additional inquiries that you would like me to ask of the buyer? And if I'm acting for a seller, local authority or county council, I would always ask the estates team to answer additional inquiries that are generated by the buyer. Remember, a buyer can't undertake a fishing exercise and just ask a whole scattergun of different questions, but can raise additional inquiries that the seller should respond to. As far as searches are concerned on acquisition, remember there's no such thing as usual searches. There are searches that are transaction, client and property specific, and indeed location specific. These days there are search providers that you can utilize that will tell you the searches that are available on acquisition. I would always say to my estates team, there are searches that are essential. Local land charges search, of course, and drainage and water search, environmental search, and as far as other searches are concerned, a SIM search might be appropriate if we're acquiring unregistered land or complex registered titles. There are then searches that might be appropriate depending on what our objective is. If we're undertaking excavation work, it might be necessary to do a geological search. If there is an issue with regard to development, there might be infrastructure searches that might be appropriate. All of these things require addressing. I always worry when conveyancers talk about, do you want me to undertake the usual searches? Because, as I say, there are searches that are necessary, that must be done, but then there's a whole raft of other searches that might be appropriate. Therefore, I think it's useful to tell the estates team as to what searches are available, what searches are out there that might assist the client. When dealing with searches, remember the limitations relating to searches and make sure that you're telling your estates team about those limitations. Do understand and appreciate that with regard to local land charges, etc., your local authority is going to be aware of them in any event, but also be aware that a traditional buyer would be looking at additional inquiries of local authority and optional inquiries as well. So again, it might be that the estates team and your local land charges team can provide information, background information relating to acquisition. As far as disposal is concerned, again, the buyer would be undertaking due diligence, they would be undertaking their own searches and making their own inquiries of the local authority, albeit that the local authority and the seller are one in the same. Moving on, as far as commercial transactions are concerned, in addition to due diligence, in addition to disclosure, etc., we do have to consider the issue of tax. As far as SDLT liability is concerned, it's important to understand that on certain types of acquisition, there can be obligations to submit additional returns. We do have to be careful about issues relating to linked transactions. We do have to be careful about apportionments that can impact on SDLT. And a big issue, particularly for local authorities, is the VAT status of buildings on acquisition. Also be aware of capital allowances too. So what I'm saying here is, as part of your due diligence exercise on acquisition, issues such as SDLT liability, the VAT status of buildings, etc., the position with regard to capital allowances needs to be clarified in case of an issue or a problem arises as a consequence. The next thing I want to talk about are surveys and physical inspection. Absolutely essential that when you're dealing with a commercial transaction, you are aware of the need to advise your estates team of the benefit of survey. And that survey can be an internal survey by a member of your estates team who's appropriately qualified, or it may mean it's appropriate to instruct an external advisor to carry out the survey or valuation on behalf of the local authority. That's not really the point that I want to explore, however. The main issue I think that's important where a local authority is acquiring property is the need for physical inspection. Remember that if you're buying property, you are bound by anything that a reasonable inspection would have revealed, whether your inspection revealed it or not. So if an estates officer is going out to have a look at a building, it's imperative that that estates officer, particularly if they're inexperienced, understands the significance of that inspection and what they should be reporting to you. They should inspect target property to identify physical defects and state and condition of the property. They should be inspecting the property to identify the scope and extent of its physical extent. Is what we see what the documentation provided by the seller reveals? We've got to identify whether information provided by the seller in replies to commercial inquiries before contract is acceptable and correct. And finally, we've got to identify whether or not there are any overriding interests that exist. Remember, an overriding interest is an interest that doesn't have to be recorded on the title, but which will be binding on a buyer in any event. It is therefore essential that our estates team, when they're inspecting, are aware of what overriding interests are. Examples of overriding interests would be prescriptive easements, easements acquired due to long use. So we're buying a site in, there is evidence that neighbours, landowners, members of the public have crossed the site because there's a well-worn path across the cleared site. If those members of the public have used that as a means of access and egress for a period in excess of 20 years, even though it's not noted on the title, we're bound by it. And yes, the seller should have revealed its existence if it wasn't obvious on inspection. But if it is obvious on inspection, the seller is not obliged to disclose it. Other examples of disclosable interests: leases with a term of less than 3 years. Don't need to be noted on the title, don't need to be registered, but are potentially binding on a local authority in any event. Remember, your estates department is bound by anything that a reasonable inspection would reveal, bound by anything that they actually see, and also be aware that there is a concept called imputed notice. If the local authority instructs someone to inspect the property, an independent surveyor, a managing agent or something of that nature, and they become aware of something, then it's important to understand that your local authority is bound by what is revealed to them. And therefore, anyone that inspects the property that isn't an employee of the local authority should be reminded of the need to report to you anything that they see during their inspection. As part of the due diligence process, it's important that we review our title and that we submit to our estates team or whoever has instructed us a report on title. As far as that report on title is concerned, we'll talk about that in a moment or two. Again, if we're dealing with an acquisition, how's the transaction going to be funded? Just talking to someone this morning in a commercial transaction where the local authority accepted a reduced deposit of 5% on a commercial acquisition. And you can guess what's coming, can't you? The buyer defaulted at completion. In those circumstances, immediately the day for completion has passed, the buyer is obliged to pay the balance. But the buyer not only doesn't have the resources to complete, but doesn't have the resources to pay the balance that's outstanding. Always be careful where your local authority is willing to accept a reduced deposit on any type of transaction, on the basis that if the buyer defaults, the likelihood is you're not going to get the rest of the deposit back. Again, with regard to completion statements on commercial transactions, watch out for apportionments, particularly where you've got a multi-let building and you've got ground rent, service charge issues, insurance rent issues that need resolving and need clarifying. That, in essence, is our first webinar, looking at some of the basic issues with regard to commercial transactions. So what we can do now is we can have a look at some questions and see if we're able to deal with them. So we've got about 7 or 8 minutes to deal with some questions before we finish. So I'm going to ask Stephen if there are any questions so far. And if they're not, you feel free, delegates that are attending today, to ask as many questions as you like. If we don't get any questions, I've got some other points that I want to sort of make before we finish. But Stephen, are there any questions as yet?
Yeah, thanks, Ian. Just as Ian says there, if anyone would like to get in touch and ask any questions, please feel free to do so using the text section of your control panel. Ian, we are very quiet on the questions front today, actually, which
Okay.
is slightly surprising. I mean, one thing that I not necessarily want to ask, but I mean, you focus a lot on the report and title towards the beginning and the end of the presentation there.
Yeah.
Well, and you were talking about the estates team, the need to maybe consider them and maybe not producing a 40-page report and title. What was the standard form that you said? Where was that available? The standard form?
Yeah, great. The City of London Law Society, Stephen, has a model form of report title, which anyone can download and utilize. And I always say to practitioners, it's worth, even if you've got a report on title that you're used to, it's worth just having a look at the model form on the basis that this is, I think, an industry accepted form of report on title that you could use. So I'm not saying it's the one you've got to use. I think it's a good idea to have a look at it as against whatever you're using. Just as, Stephen, the RICS model heads of term for commercial leases. A local authority can devise its own form of heads of term for commercial leases, but there is a model that you can compare and contrast. And therefore, I think both of those documents are worth looking at and are worth comparing against what you're currently utilizing. But the other point, Stephen, that you make there, which I think is very interesting, it's all well and good having a standard form of report on title that, Stephen, if you're head of estates, I'm sending to you. But we should be asking the question, and we should be spending a bit of time together to saying, well, look, is this what you really want? Could I not sort of personalize it so that the key information that really is the deal breaker, or really is something that's going to get you unable to sleep at night, is drawn to your attention? Because I used to do some work for a client, and at one stage, the estates department of this client was about 20 strong. Last time I was talking to them, there were 2 people doing 20 people's work. And what they were saying to me was, look, we're spending our days firefighting. So if you send us a report on a commercial lease that's 50 pages long, you're not helping us. In essence, you're hindering us. And what's going to happen is we're not going to read that, or we're not going to be able to read it for 4 weeks till we've got a little gap where we can spend some time and have a look at it. Far better to say to someone like that, right, what's at the heart of your decision-making process? What do you really need to know about? And providing that information. Yes, providing a report on title that's all bells and whistles as well, but enabling the client to make a decision with regard to the key issues. Now, you can have, the other thing, Steve, you can have a protocol with your estates team, where the estates team are saying, on a standard form of startup lease, for example, these are the only things that we really need to know about. Or these are the things, if a tenant comes back and says he wants to vary the lease, these are the things that we're willing to accept, and these are the things that you need to report back to us. So what you can do is you can create a raft or a suite of documents that makes life a little easier, that makes the sort of transmission of information backwards and forwards more relevant and saving time. So I'll say it again, City of London Law Society's Land Law Subcommittee standard form of, it's called a short form of report on title. There's also a certificate of title on there that you could use for the purposes I mentioned a little earlier. As far as concerned, the RICS model heads of term are useful. I'm not saying they're the sort of finished article, and with local authorities and commercial leases, you might be drafting a standard full-blown commercial lease to a blue chip tenant, but then in the next day you might be offering up a startup tenancy of a workshop to a new business. You're not going to use the same form of lease for each. That website that I mentioned, the commercial lease website, contains variances that would be useful in those circumstances. Does that answer the question, Stephen?
Absolutely, thanks, Ian. And yeah, it's probably worth pointing out as well within the notes, which I think everyone should have in the notes section or the handout section of the control panel. There is a section on reporting on title, and it has actually quite a lot of that information you've just shared there, which I think is very, very useful.
Good. Any questions?
We just have one question in actually from Jonathan. Jonathan asks, how long are adverse possession applications taking at the land registry? There's a nice curveball to you there.
Yeah, great question. Last time I dealt with one, I was told 3 months. But what I can do, Jonathan, is what I can do is I can get some up-to-date data on that, and perhaps I can share that with people next week or next time. I think it's next week we're together, isn't it? Yeah, can share it with people. So, Jonathan, I'll have a look at that, and I'll get the inside track and tell you what the current status is. But that's what I was told on the last occasion I inquired. We're going to talk about adverse possession in a lot more detail, Stephen, because it's quite local authorities, because they have such huge land banks, because they have limited resources with regard to managing their property portfolios, they're vulnerable to adverse possession. So we'll be looking at that in a lot more detail as the series progresses.
Excellent, thanks, Ian, and thanks, Jonathan, for that question.
Yeah, that's Jonathan.
Ian, you said, I think, that you wanted to maybe just make a couple other points or summarise. It looks like we are a bit quiet. I would just say to everyone, if you have any questions, perhaps you can't think of them now, please do send them on to us. There will be further correspondence from us in the coming days. So if you have any questions, just respond to those emails and we'll be happy to answer them. But Ian, please.
The 2 points I was going to make, I deal a lot with, what goes wrong in conveyancing transactions. I see a lot of nightmares and things that go hopelessly wrong. And what I say to practitioners is most of the time where, something goes wrong, it's a failure to do the simple things well. Effective communication, spotting problems at the start of the transaction and coming up with solutions or highlighting what those problems are so that we're not, during the life of the transaction, all of a sudden being surprised and then having to deal with something on the hoof. So I think preparation is key. I think with residential transactions and commercial transactions, I don't like the idea of what I call combat conveyancing. The idea of scoring points and, I've got to protect my client's position at all costs. Yes, we've got to act in the best interest of our clients. Yes, we've got to be protective of our clients, but at the same time, we've got to get the job done. And sometimes, being sneaky or thinking, well, hopefully the buyer won't spot that. The buyer might not spot that, but the buyer might spot it somewhere during the life of the transaction. That means all of a sudden the deal that was hot and was on is all of a sudden off, which again, can cause difficulty, causes abortive costs and problems associated with it, which are problematical in themselves. Stephen, you mentioned about contact addresses. I've just put Robert and my email address on the slide there for anyone that has any questions.
Perfect, thank you, Ian. That's great. So, Ian, if you're happy, I think we'll wrap up there for today.
Absolutely.
As Ian says, we will be back next week. That just leaves me to thank everyone and to Ian for attending today's session. As I say, if you have any questions, please do contact Ian, myself, or Robert. Once you leave the session today, you will receive an automated email from GoToWebinar. If you respond to this email, the replies will come directly to me, so I can send on any questions and feedback or answering to myself. You will also receive a separate email from Robert in the next couple of days, which will contain the slides and notes to today's session, as well as a recording of the session. So that just leaves me to say, on behalf of Stewart Title and Ian Quayle, thank you very much for joining us today and have a great rest of your day. Thanks, everyone, and goodbye.